Results might be worse than this.
I don't know. That's pretty bad.
Good evening, friends, and thank you for being with us tonight. Welcome to the Daniel Webster Debate Series, hosted by the Georgetown Law Federal Society. This series is dedicated to Daniel Webster, one of our nation's most revered orators and public servants. Webster relied on the strength of his ideas to advance the American people's liberty and prosperity. He is rightly remembered as a great expounder and defender of our Constitution. Our resolution tonight is should religious conscience rights supersede anti-discrimination laws. This debate is of remarkable importance to our significantly religious and diverse nation, and we are humbled to have such incredible speakers to discuss it. We're deeply honored to host Alabama's finest, the Honorable Andrew Brasher of the United States Court of Appeals for the 11th Circuit as our esteemed moderator. To lead us off tonight, we have brilliant advocate Aaron Hawley, who serves as Senior Counsel and Vice President of the Center for Life and Regulatory Practice at the Alliance Defending Freedom. To meet this challenge, we're thrilled to have the fearless Senior Litigation Counsel for Reproductive Rights and Health of the National Women's Law Center, K.M. Bell. We're deeply grateful to the Federal Society and to Georgetown Law for making the Daniel Webster Debate Series a reality. With that, please give them a very warm welcome. Thank you.
All right. Well, it's really fun to be here. Like I was telling Brady earlier, I can't imagine trying to put on something like this series of debates when I was in law school. It's just so impressive that y'all are doing this. And this topic is something that is so interesting to me. I mean, this is something that has interested me while I was in law school. Really, it interested me like way back in the Stone Ages, even before I went to law school. So I was really excited about the topic. So our question is, should religious conscience rights supersede anti-discrimination laws? And just a couple of quick thoughts on this before I pass it off to the panelists to kind of just set what I think this is about. So I think this question presents a dilemma that you see a lot in constitutional law and really just in law generally, which is the need to balance two constitutional principles of equality and liberty, right? So the First Amendment reflects the principle that people should be free to exercise religion without government interference or coercion. You know, that liberty is really at the root of arguments that there should be religious exceptions to generally applicable laws like anti-discrimination laws. The 14th Amendment, on the other hand, and the Declaration of Independence, reflects the principle of equality, reflects the idea that people should not be discriminated against because of historical prejudices or superficial considerations like race or sex, things like that. And so that principle of equality really is at the root of anti-discrimination laws. And, I think the debate is about how we balance those things. And so because we're at law school and because law is literally the only subject upon which I am qualified to talk about, I wanted to talk about just a little bit the way I think to kind of situate this debate in law as opposed to policy. And specifically, I just want to just set the debate by walking through 4 Supreme Court cases where I think the Supreme Court has, in my view at least, tried to balance these interests in different ways. And I think like the way the Supreme Court balanced the interest kind of come back into this debate on a regular basis. So let's start with 1983 in the case of Bob Jones University versus United States. How many of y'all are 1Ls? 1Ls? Okay. So in Bob Jones, the court had to decide whether the IRS violated the free exercise clause by denying favorable tax treatment to schools that basically the schools discriminated against people on the basis of race. They discriminated against interracial dating. They discriminated against Black people. And they did that based on a reading of the Bible that they had. And so the question for the court was, could those religious objections supersede anti-discrimination tax policies? So the tax policy said, if you want to get this favorable tax treatment, you can't discriminate. And the court said no. The court said, applying strict scrutiny, that the IRS's denial of tax benefits was the narrowest means to achieve the government's interest in eliminating racial discrimination in schools. And it said that that interest substantially outweighs the burden placed on the school's exercise of their religious beliefs. About 3 decades later, in 2010, the court favored anti-discrimination principles again in a case called Christian Legal Society versus Martinez. And in that case, you had a chapter of the Christian Legal Society at UC Hastings Law School, which is now UC Law San Francisco. It was denied official status by the law school because it didn't comply with the school's non-discrimination policy by excluding homosexual students. And so the question there was, did Hastings Law School, did that non-discrimination policy violate the free exercise clause as applied to the Christian Legal Society? And the court said no, again. And it said that the non-discrimination policy wasn't targeted at religious groups. And it said that it was unfair, really, for the Christian Legal Society, quote, to seek not parity with other organizations, but a preferential exception, end quote, from the policy. Things took a different turn a few years later in a really important case called Hosanna Tabor versus the EEOC. And there, the court held that the religion clauses barred a disability discrimination suit that was brought by a minister against a church that had fired her. And this was a 9-0 case. And the court held 9-0 that religious groups have something called a ministerial exception to laws that would restrict who they could appoint to be their minister. The idea is that the Constitution gives, quote, a special solicitude to the rights of religious organizations, end quote, to decide who's going to lead them. And then applying that ministerial exception to the facts of that case, the court said that religious groups couldn't be sued under the Americans with Disabilities Act for firing their minister. And the final case I just want to highlight is a case called Fulton versus City of Philadelphia from 2021. And the question there was whether the City of Philadelphia could refuse to renew a Catholic foster agency's contract because that foster agency did not certify same-sex couples to be adopted parents, and that was in violation of the city's non-discrimination policy. And there were really broad arguments in that case, but the court resolved it very narrowly in a 9-0 decision that ruled in favor of the adoption agency. And they said that because the city allowed individualized exceptions to its policy for other groups based on other considerations, that it needed a compelling justification for denying a religious exception to that non-discrimination policy. So I think these cases give us 4 really interesting ways to think about this question about balancing religious rights and anti-discrimination. And so roughly, I'll just kind of walk through what I think these cases stand for. So 1, Bob Jones said that religion is special, but anti-discrimination laws are even more special. So there shouldn't be religious exceptions to such important laws. That's one way to think about it. 2, Christian Legal Society said really that religion as a general matter is not special enough to be exempt from laws that apply to everyone else. And in fact, maybe religion shouldn't be treated preferably to other considerations. Third way to think about it is in Hosanna Tabor. And it said that religion is special enough, at least in certain circumstances, that it should get exemptions from anti-discrimination laws. And it sort of suggested that those exemptions are generally a good idea and favored those exemptions. And the fourth way to think about this is in Fulton. And that said that, look, if there are religious exemptions, then there should if there are non-religious exemptions, then there should be presumptively religious exceptions to as well to a non-discrimination policy, because otherwise the government is really discriminating against religion in what it's doing. And I think we see those same 4 positions reflected in broader debates on this issue. People who oppose religious carve-outs to non-discrimination policies often say, like the court in Christian Legal Society did, that there's nothing so special about religion that warrants an exception from a generally applicable law. If non-religious objections don't get an exemption, then why should religious reasons get you an exemption? They also might say, okay, look, maybe there are some laws where you should get exemptions. Religious exemptions aren't bad in and of themselves, but like the court did in Bob Jones, they might say that, look, anti-discrimination laws themselves are just too important and too meaningful to allow religious exemptions to those particular laws. On the other hand, people who support religious exemptions often say, like the court in Hosanna Tabor, that religious exemptions are good in and of themselves because religion is special, it's historically important, it's in the Constitution's text, and you need exceptions, maybe, as a religious person, and able to live your life according to your beliefs. And then often, as in Fulton, they may say that to disallow religious exceptions to a non-discrimination policy itself is tantamount to discrimination against religion. So, there are a lot of other things to talk about in this area. There are a whole host of arguments about how practical it would be to have religious exceptions, what the scope of any exception would be, how we would ensure that religious objections to non-discrimination laws are sincere and aren't just based on sort of economic or financial rationales. And so this is to set up this debate between 2 people who are smarter than me to talk about this. And so first, we're going to hear from Ms. Holly. So I will turn it to her first.
Thanks so much for having me. Thanks so much for having me and just, yeah, a fantastic setup to see how the court has perhaps, I think it's difficult to reconcile all of those cases. So it's a great introduction to see how different ways in which the court has looked at this challenging question of balancing competing rights. So wanted to mention at the first is that I have to disagree a bit with the premise. The premise is, should religious conscience rights supersede non-discrimination? And I think in most instances, not all obviously, we just heard about several cases, but in most instances, those rights can coexist quite peacefully. If you think about since Smith, and I'll talk a little bit about that, but since RFRA, there's also 21 baby RFRAs in 21 states. And a neat piece by Mark Storsley in the University of Chicago talks about how most of the cases we see regarding RFRA are cases probably most of you who sort of disagree with religious exemptions would find very sympathetic. Most cases involve things like hair length, like headgear, buggies, beards, religious diets, and things like peyote. So these sorts of things that religious minorities typically, not always, but are required by their religions. There's a state law that says you can't do this for whatever reason. Often they're in the prison context. And so these RFRA statutes come in to say, no, actually the burden on the government isn't that large. The burden on the religious right is substantial. So you do have a lot of sort of, I think, interplay where free exercise rights are also supporting non-discrimination principles as well. So they can coexist. And then another thing to recognize is that we have a lot of religious exemptions in our laws. So the main one, of course, is RFRA. It applies to any federal action. There's RLUIPA, but that was held unconstitutional, except in the land use and prison context, which is probably right, but an interesting decision. And then you've got the question of what to do with the different congressional statutes. I had a chance to argue a case. I lost it 9-0. Not a great record, but in my defense, the reason I lost it is because the government changed horses midstream. They said initially that doctors did not have conscience rights to that allowed them to say that I'm not going to perform an abortion. Then they told the Supreme Court, actually, you've got really broad conscience rights. And so we see this in the Coat Snow Amendment, we see it in the Hyde Amendment that prohibits federal funds for abortions, we've got the Weldon Amendment and the Church Amendment. So we've got these broad, both sort of legislative exemptions, and then we've got some that are judicial. And the free exercise challenges are typically analyzed under the Smith rubric now. In Smith, a decision by Justice Scalia, the court reversed course in Sherbert versus Werner. The court had said in a case involving an employment dispute that if you had a sincere religious objection, if a religion was substantially burdened, then the government had to show a compelling interest and that it was narrowly tailored, that the regulation was. In Smith, Justice Scalia said, nope, sorry, if it's neutral and generally applicable, then religion isn't special. You don't get a pass from a neutral and generally applicable law. You get to sort of be religion's not special. Since that time, the court, I think, has narrowed Smith. They refused, as you alluded to, Judge, they decided not to overrule Smith in Fulton. They had, I think, 4 votes for that, did not have 5, had a bunch of concurrences. And in the Fulton case, the court was clear that there are 2 independent ways to sort of get to strict scrutiny, even through the Smith framework. One of those is the law neutral. The second is it generally applicable. The neutral principle, I think, is really interesting. In the COVID cases like Tandon, cases like Calvary Chapel, the Supreme Court and lower courts were confronted with these regulations that said if you're going to do things during COVID, you can have a liquor store, you can go to casinos, but you really shouldn't go to church. The court said, that's not a neutral provision, that religion is not treated as well as secular activity. So you get strict scrutiny. The same is true if you have hostility, like in Masterpiece Cakeshop, or if you have exemptions like in Fulton. And so in Fulton, the court, as Judge Brasher said, took the narrow path. They said here there's discretion, that they allow the city to look to other factors. Actually, even race was one of the factors that was considered in placing children in Fulton. And so they said, given that, the state can't justify its sort of non-accommodation of religion. And then the last thing I'll say, and then we can talk a lot more and answer questions, but is Fulton, I think, maybe described a way forward. It probably won't satisfy everyone in every case. But all 9 justices signed on to Fulton, and they were confronted with this very dynamic, where you have a free exercise right. There was no disputing that the Catholic charity at issue there, they firmly and sincerely believed in a traditional view of marriage. They also believed that they needed to help orphans. The Bible says you've got to help those that are in situations like being motherless and fatherless. But the city said you can't do both of those things. You can't be engaged as a licensed foster care provider in our city and hold these views on marriage. So clear conflict between discrimination principles or public accommodation laws and free exercise. And all 9 justices said something interesting. They said that the foster care CSS there seeks only an accommodation that will allow it to continue serving the children of Philadelphia in a manner consistent with its religious beliefs. It does not seek to impose these beliefs on others. And I think what the court meant by that was that there were other not Catholic, but there were other foster care agencies available. During the oral argument, several times it came up that this particular agency, CSS, hadn't even had any same-sex foster parents come to them. They went to all these other agencies that existed. So I think that what the court was saying here is that we can accommodate religious beliefs without harming equality principles, at least in a situation where there is the ability for both to be accommodated.
Great.
Well, I was prepared to rephrase the question because it was originally, should religious freedom supersede anti-discrimination laws? And we all like
So
freedom.
you both agree that the question was bad. I like starting from a good.
Well, and we both agree that many of the RFRA cases, particularly in the prison context, do come to the correct result in the sense that people who are incarcerated should be able to practice their religion and not be unable to do so because of a haircut rule. So there is definitely a point of agreement that we can start from there. But I do want to just define what discrimination is, since I think that's important. And I Googled this, so you can too, but it is the unfair or prejudicial treatment of people and groups based on characteristics such as race, gender, and sexual orientation. Implicit in that definition are embedded a couple of normative judgments, right? One is that this is unfair, and the other one that's maybe a little bit more subtle is that those categories are not relevant to the decision that's being made. If you are discriminating or categorizing people based on their credit score for renting an apartment, we would not call that discrimination, but if you're categorizing them based on race, we would, right? So then the question becomes, well, what are these categories? Or what should the categories be, perhaps, since this is a should question, which I do appreciate. And there we can kind of look at the protected class analysis, right, from equal protection law. One question is it immutable? Meaning, are you born that way? Although hilariously, religion fails this test miserably. A 2023 survey found that 24% of Americans have switched religious traditions, which was actually way more than I thought it was. So that was very interesting. So religion, definitely not immutable. But categories like race and sexual orientation are, is it visible? Meaning, is this something that, potentially someone could tell by looking at you, or at least thinks that they can? And then, has the group suffered from discrimination historically? Have they experienced a history of purposeful unequal treatment, or been subjected to unique disabilities on the basis of stereotype characteristics not indicative of their abilities? And this is a factual issue, right? I think we're seeing that play out right now. Although I strenuously disagree with this in the context of the transgender military ban, where the factual dispute is does being trans impact your ability to serve in the military? Or is it just one of these other categories that we should not distinguish based on? And is the group able to protect itself in the political process? Again, trans people being a good example here, being such a tiny minority of the country, are not able to elect representatives of their choice anywhere. There just simply are not enough people. Another thing that I think is highly relevant that maybe does not get the same attention is whether the government itself has been part of the discrimination. And so particularly where the laws themselves have been discriminatory rather than just maybe one individual government official being biased in their minds. And this, in the 1960s and 50s, there were mandatory segregation laws. So it wasn't just the individual person deciding, I don't want to serve Black people. In some municipalities, they're actually required to segregate. Other examples, cross-dressing bans, criminalizing cross-dressing, targeting trans and other gender nonconforming people. The fact that gay people couldn't get security clearances from the federal government until 1994 or 5, which also is surprising. And in many states, people of certain religions couldn't hold public office until like the last of those laws was struck down in the Supreme Court in 1961. So for the purpose of this, I'm assuming that we're largely talking about laws that impact private actors, right? Obviously, laws that the government not discriminating is something that we can handle under the equal protection clause rather than these non-discrimination statutes. Non-discrimination laws are a relatively new concept in this country. There was an attempt at a Civil Rights Act in 1875. That was struck down by the Supreme Court. Sort of the seminal Civil Rights Act was in 1964. So in the history of our country, this is relatively new. And all the way along, there have been religious arguments. There were religious arguments used to justify slavery. In the Piggy Park case, the restaurant owner based his refusal to desegregate on his religious beliefs. And you already mentioned the Bob Jones case, which I think was the end of those arguments, at least in court on race specifically. But there were religious arguments against slavery. There were religious arguments in favor of the Civil Rights Act. I would argue that courts should really not take a position in these debates about whether racial discrimination is justified or forbidden by religious doctrine. That's going to cause establishment clause problems, and it's not something the court can decide. But courts have held repeatedly that someone's religious belief in segregation does not and cannot justify discrimination in violation of, as the Bob Jones case called it, a national consensus. So what purposes do these laws serve? Economic, societal, if we want to have a functioning, pluralistic, multiracial democracy, there has to be tolerance of people with different views. There's also a dignitary harm. Discrimination is psychologically harmful to individuals who experience it. And this is, I think, where we disagree on Fulton. There's actually a case in Tennessee of a Jewish couple that was denied adoption services because they were not Christian, and had spoken more eloquently than I could about the harm that caused them from experiencing that discrimination, whether or not they were able to find somebody who was willing to serve them. And then there's a symbolic interest as well. This was a much bigger deal in the Cold War, but the United States holds itself up worldwide as a free society, and I think there's an interest there. Sorry, 7 minutes is short, so I'm going to skip a lot of this. So what does the First Amendment Free Exercise Clause actually protect? I think it's clear to all of us that it protects your personal beliefs. The question is, what conduct should it protect? I think we can all agree it protects the right to go to church and to pray, but depending on how religious you are, everything you do is arguably the practice of your religious beliefs. And so the idea, and there are greatly conflicting sets of beliefs out there. I was thinking about this on the way here, and I'm like, is there any law that we can say that there are no religious objections to? And I was like, maybe murder. But no, because I actually used to work with people who, for religious reasons, were very opposed to felony murder laws. I think there are folks who, for religious and other reasons, would disagree on where self-defense begins. and that those are legitimate debates. I think that some people would call the death penalty murder for religious reasons. So at the highest level, we can all agree on murder, but when you start delving into some of the specifics, not so much. And that is where I think Smith comes in. In order to have a sort of a functioning society, you have to comply with neutral generally applicable laws, whether you agree with them or not. The problem with RFRA is that the principle, and I think the distinguishing principle between the cases that I agree with and the ones that I don't, is the do no harm principle. It does not harm anyone for someone to wear a turban or have long hair in prison. There's a argument that, okay, it might be slightly inconvenient for some of the people who work in the prison, but that is not a meaningful harm. Discrimination is. And so I think that there is a principled way to distinguish. There's also the issue of, whether or not this is a government regulation or, something that is impacting private individuals. I could go on, but I suspect I'm over time, so I'm also, oh, I have a minute, okay. Great, thank you. There's also, I think, this idea of complicity that I want to address. I don't disagree that complicity is problematic and can be deeply upsetting for folks with deeply held religious beliefs. But I would say that one of the worst examples of complicity is somebody who is deeply opposed to war who has to pay taxes. We spend trillions of dollars on the military, and if you are somebody who is strongly religiously opposed to that, you might say, well, why, if complicity is the issue, which is, the cases like Hobby Lobby, then why do I have to pay taxes? And the answer is basically because we can't administer that, right? Like, it is too complex. And it is unfortunately a sacrifice that we have to make in the society. Unfortunately, right now, as we sit here in April, that we all have to pay taxes, and we all have to comply with generally applicable laws.
All right, I think now that's probably a good.
Yeah, okay.
I saw you had several more pages of notes, so I.
Well, I'm not a law professor, so I had to try to refresh my memory.
Me too. I'll ask. She responded, I'm sorry, Kay and Bell responded to some of the things that you said, but I want to ask you if you want to respond to some of the things that were said.
Sure, thank you. And I think that there's actually a fair amount of agreement. So I think the reason fundamentally that religion is special is because we have the First Amendment. And if you think about the First Amendment, it protects numerous rights. The first one, or among them, the right to free speech, and it also prohibits any law affecting or infringing on free exercise. And so when you think about free speech, if you think about the Barnett children, or if you think about an artist who's being asked to create a poster board for a you can do it on both sides of sort of the ideological spectrum. You can have it on one side for traditional marriage, and on the other side for same-sex marriage. But if you ask someone with fundamental beliefs to create it for the other side, that's compelled speech. And under 303 creative, you get strict scrutiny. That doesn't happen with the free exercise clause. And I have not heard, at least to me, a convincing argument as to why that's true. Why is there this distinction other than, as Kaya mentioned, simple sort of administrability? I think Justice Scalia, maybe didn't like drugs, and he also probably didn't like these administrative hurdles that a sort of exemption would come into play. So I think the First Amendment, we have to deal with that. Religion is special under our Constitution. The other thing I thought that was good to hear is about the dignitary harm. Of course, there's dignitary harm when you refuse service. I don't think anyone is denying that. But I think on the other side of that, there's also deep dignitary harm from being forced to choose between your religion or helping foster care children. As Chief Justice Roberts' opinion pointed out in the Fulton case, Catholic charities have actually, they sort of created adoption and foster care services. And the state came in and now they were licensed, but now they were saying, you either have to hold to your religious teaching or you can help kids, but you can't do both. So that absolutely is a dignitary harm. I had a quote here from Thomas Jefferson, who we know, as the famous wall of separation of church and state, but was actually very pro conscience rights. And he says there's no provision in our Constitution that ought to be dearer to men than that which protects the rights of conscience against the government. And I think those rights of conscience clearly under the understanding of the framers, and even the Supreme Court today, include not only the right to your own personal beliefs, not only the right to personal prayer, but also the right to act in ways that are compelled by your religion. And then finally, of course, there's these hard hypotheticals about, does my religion allow me to murder people I don't like, or, that smell bad, or whatever crazy thing you can think of. But the reality is, of course, it doesn't. Smith certainly not. But even under RFRA, even under Sherbert versus Werner, there is the compelling interest test, which says, religious liberty is precious, but it's not absolute. So where you have a compelling government interest, then the government can say, sorry, we respect your religious beliefs. Sometimes you can question sincerity, but judges don't like to do that very much. So that they usually go to strict scrutiny and the failure of the government policy to advance a compelling state interest.
Anything you want to respond to?
I also love the First Amendment, so we can agree on that too. I most recently used it to overturn a criminalization of recording police officers, as well as attempts to ban drag. So big fan. But you were didn't actually say this, so I'll say it. I think Smith was wrongly decided, although not for probably the reason that you do, but actually because I don't think the social contract that our government is based on gives it the right to police what people can and cannot do with their own body. We have been talking a lot about, of course, things at the federal level, but there is a disturbing lack of seemingly any doctrinal limits on state police power, which I think is something that maybe that's debate for another day, but something that we should start taking seriously. In terms of the foster care system, I think the issue there is that is essentially like government services being done by a private actor. And I think that when someone is performing governmental or quasi-governmental functions, in Arizona, there are private DMVs. It's actually great and efficient, but there's also the regular state-run one. But as just another example, maybe a little less controversial example, or when someone is taking government funding to do whatever it is that they're doing, that they should not be able to discriminate, because essentially they are, either the government is enabling and facilitating that by providing the funding, or they're providing a sort of governmental role. I imagine when the Catholic Charities started, the foster care system was not so much the province of the government. But obviously we're in a very different place now than we were a century ago, or however long that was. I'm not stopping.
All right, that's great. Well, thank you all. I have so many questions for you all. I'll start with this one. So the idea of dignitary harm came up, and I think there are hard hypotheticals for sort of both sides of this debate. You could have the sort of, there's one pharmacist in a small town and doesn't want to fill particular prescriptions, so nobody can get the prescriptions. That's sort of like, I think, your hard hypothetical. Your hard hypothetical might be like, there's 1,000 bakers in Manhattan and there's only one of them that doesn't want to make a cake for same-sex weddings, right? So you can get it from anybody else. How much should sort of the practical consequences of an exception or a superseding, or however you want to say it, how much should that matter, and how much should it not matter? And I guess I'll go with you first.
Yeah, I think that's a really good question. There's been, as you no doubt know, there's been a huge sort of scholarly debate on this, the whole concept of dignitary harm. And that was one of 3 justifications for the Philadelphia law. One of them was they wanted as many kids as possible in foster care. One was, I think, efficiency. And then the third was they wanted equal treatment for all of the families. So the court said the first 2 were actually helped by Catholic Charities, so they don't count. And the third one, it said we have no doubt that those are weighty interests, but if they're not compelling, at least, whereas here there are sort of other avenues. And the state's rationale doesn't really make sense because they offer other exceptions. So I don't think the court has directly grappled with that. I think if you look at cases in the free speech context, the court has grappled with those questions. It's sort of a fundamental free speech principle, that you can say something even if it's very hateful and awful, and we all think it shouldn't be said. So there's, the Westboro Baptist case. There's famous example of the ACLU defended the Nazi Skokie sorts of things where they marched through the Jewish neighborhood against something that's reprehensible but protected by a First Amendment. So I don't think under broad First Amendment principles that dignitary harm probably gets you far enough.
Okay, but I suppose you would concede that other kinds of harm might get you there.
Yes.
So and the pharmacist can't get my prescription.
Yes.
Okay. What do you say about that?
Well, I think the interesting thing about Smith and sort of the problem that it's created is it's incentivizing, legislatures to just create laws with no exceptions. Because then you get to court on the challenge, and if there's any kind of exception, however reasonable, now all of a sudden you have a problem under the current case law. That's not how legislating should be happening. And I don't know, I have the good or perhaps misfortune of also having been a lobbyist and seeing how the sausage gets made. One time there was a bill with a 4-year time limit on waiting period for expungements, and somebody asked me why 4, and I said because it's between 3 and 5. There actually was justification for 3. There was no justification for the other numbers. But this is how legislation gets made, right? And so and it makes sense, like looking at, say, Title VII, right? Title VII, the employment discrimination law, only kicks in at like 15 employees. Why is that? Well, I think that no employer should discriminate against people, but also acknowledge that there are times where complying with non-discrimination laws puts a burden on a small employer, perhaps even defending a lawsuit that may or may not be justified, is a huge burden. And the time and money that it takes the federal government to try to enforce this law is also a burden. And so maybe it makes sense to focus on larger employers. So there's a number of good reasons. Also the fact that, if you're running a small restaurant, maybe you want to hire members of your family, that might lead to some racial imbalance in your employees because you're related to them. And perhaps that is not discrimination, right? So, but it could, to the outside world, maybe look like it is. And so for all of those reasons, I think having a thoughtful debate in the legislature about the pros and cons here is important. And what we do when we sort all of this out in court is put these policy decisions onto judges who, no offense, are maybe not the best equipped to make these decisions. And so perhaps, having a RIFRA case about it every single time we want to debate the merits of an exception is not actually the best way to resolve this as a society.
What do you say? I mean, so just to press you on the question I ask.
Please.
What do you say about the idea that, look, we should be focused more on whether, the protected class is actually getting the services that they need or want, and not about sort of dignitary harms, but about sort of financial harms, service harms. And then there might be a difference between, the Bob Jones case where we're saying like, we don't want to, the university saying we don't want to desegregate, and some other case where it's about, getting a flower arrangement that you want or something like that.
Well, I think they're still getting the services that they need was an argument made in justification of segregation, right? That was the whole separate but equal argument. And before you say no one would make that argument today, I actually heard a lawmaker suggest that trans kids could just form their own sports league. And that's just not what we do. And so I do think that it is important that people are getting the services, but it also is important in our society. There's something called the tolerance paradox, which basically says the only thing a tolerant society can't tolerate is intolerance. But I do think it's important that people be able to walk into an establishment and not have to worry about, is someone going to refuse me service because of my race, because they perceive me incorrectly to be a lesbian because of, you know, some other thing about me that is outside of my control, when you're just trying to move through the world. And I think even the harms experienced, we're seeing that now with trans youth, where there's evidence that suicidality has gone up in states that are considering anti-trans legislation. Whether or not that young person has even actually experienced discrimination, the harm is real. And so I think, you know, it is, I will have to respectfully disagree, I think, on that point.
Yeah, I think, you want to say anything else about that? No, it's fine.
I think, no, yeah,
Okay.
I'll.
All right, another question I have too, and your comments really raised this question to me about, you were talking about the historical discrimination. Should the rights of religious people have anything, I don't know how to phrase this question exactly, but should this calculus or this debate matter at all about the historical discrimination against whatever group we're talking about who's protected by the anti-discrimination law? So for example, you know, I think DC has an anti-discrimination law that actually covers politics as one of the reasons you can't discriminate against somebody, which is insane because that's like the number one rule of DC is you can't discriminate on the basis of politics. But so, you know, a legislature could conceivably identify any sort of reason. And so I guess,
Yeah.
question to both of y'all, should that be something we should consider? And you're shaking your head a lot, so I'll ask you to go first on that.
So I think, yes, as Cam had mentioned, these are relatively new laws. Of course, we have the civil rights laws, but with state public accommodation laws, they include all sorts of things, including politics and really broad categories. So I think, you know, the expansion of those sorts of protections can't just sui generis narrow religious liberty protections. So if you have a, you know, firm religious belief and whatever the issue is, just because there's a new protected category or class, I don't think that necessarily obviates that First Amendment right.
I 100% agree with you on the political affiliation. I didn't get to it because I was already going on for too long, but I think that not only is it ridiculous, but it trivializes the other things on the list. You know, and so perhaps there's a future collaboration in the works here, but but I do think, you know, thinking about religious freedom and religious discrimination, there's a long history of religious discrimination in this country, right? And I think that's where, you know, the case I mentioned about the Jewish family that was unable to obtain service, like that wasn't on the basis of their sexual orientation, that was on the basis of their religion, by, as it happens, another religious group. But I do think it is really important to consider the history, and, you know, to go back to what I said earlier, including the history of our own government, in facilitating and perpetuating certain kinds of discrimination and not others. Although I guess one could make an argument that the government has discriminated on the basis of political affiliation, but I think that is fair game.
All right. Another question for y'all, which when I look at these cases, at least as they're litigated, in my mind, there's sort of two kinds of cases. One is the kind like Hosanna Tabor, which the government is saying, you religious group, you have to do this, right? You must hire this person back or pay them damages. And that's the problem. But a lot of these cases are where the religious organization or religious person is seeking like a benefit from the government, right? So they're seeking sort of, look, we want to be a part of this government program. We want to get this, you know, in Bob Jones, they wanted to get a tax exemption, right? Is there any distinction there? Because just from my perspective, one of those seems like a stronger government sort of strong arming of religious organizations or people than the other.
So I think there is a distinction, for sure, but I don't think it makes one less of a First Amendment violation. So if you think about, you know, the trilogy, the Trinity Lutheran trilogy of cases, in those cases, you had states discriminating on religious grounds and going out of the Blaine amendments from the 1870s, which attempted to exclude Catholics from public schools. And so these states are saying you can't fund religious education, you can't, you know, we don't want religious schools to have safe playgrounds, you know, you need not apply. And the Missouri Department of Revenue, it actually came out of my home state, and the like what they issued was just incomprehensible. It's like, you qualify for this grant for playground rubber to make your playground safer, but you can't get it because you're religious. Like, that's just like crying out for a cert grant. So the court grants cert and says, you can't just say because you're a religious organization, your kids don't get to play safely. So that started off the trilogy. Then, of course, we've got Espinoza coming out of Montana, which involved tuition scholarships. You got a tax credit if you're tuition, but then the Montana Supreme Court said, no, you can't go to private religious schools. The Supreme Court struck down that. And then Maine got creative in Carson versus Mencken and said, well, actually, we're not discriminating based on religious status. You can actually be religious. You could have a religious school. You could be religious affiliated. You just can't teach religious things. And the court said, no, that's religious discrimination too. So all of those cases were benefit cases. And even Fulton was sort of a benefit case. Now I think Fulton's even a little more sympathetic to the Catholic Charities, because I don't think you have to be state licensed. Like, you can't help foster kids unless you're part of the system. But so yeah, I don't think that, I think it's a distinction, but both can be free exercise violations.
I mean, I would distinguish Hosanna Tabor, and I'm sorry if I mispronounced that, based on the ministerial exception, right? I think there's a big difference between telling somebody that they have to hire someone as a preacher or whatever they call their faith leader, versus you can't discriminate against someone in employment at your school, at your soup kitchen, at your other thing that isn't the actual faith leader themselves. And I, again, recognize that, like, for some people, everything that they do is religious in nature, but I think, again, to support the sort of functioning of our democracy, we have to draw a line, and drawing it at faith leaders is a sensible place to draw it. And, in terms of the funding cases, I mean, I think there's also the Establishment Clause, which we haven't talked about, and which I would argue is being read out of existence currently. But the idea would be that the government funding religious things is essentially a state establishment of religion. And I think there should be, whether or not there is, a difference between saying, we're giving you money for your playground, assuming anyone can use the playground and there isn't discrimination occurring. We'll give you money for your playground versus we will fund, and this is still the law, we will not fund sending someone to seminary, right? Because that is essentially the government giving money to religion, and that is actually still a belief in the law.
Narrow slip.
Yeah, I went to the law school with the plaintiff in that case, John Davies, so I can confirm he has still lost that Supreme Court case. My last question, then I will turn it over to you guys. This is like an unfair question, so I'm just going to phrase it that. So, is there any thought on originalism in this context and sort of original understanding of the free exercise clause? I mean, exemptions to generally applicable laws, and I'll turn it over to the law professor first.
So I'm just part-time now, so
Yeah.
but yes, so absolutely. I think Fulton is a good example of that. The opinions go back and forth on that. Justice Alito makes the point that these sorts of laws, that there were all sorts of things that every colony had laws that allowed religious exemptions. So these were things that the colonists were particularly sensitive to, coming from mostly Europe, and they were worried about being forced to do things like compelled religious oaths, compelled payment of taxes, sort of the sorts of things that might amount to a religious establishment, and particularly focused on coercion. So you do have those exceptions subject to like safety. So there was sort of a compelling interest has baked in. So Justice Alito's, I think, concurrence, maybe it started out as a majority, you can't really tell, then became a concurrence. But whatever happened with that case, you've got a really fulsome discussion in Alito's opinion of the history. Of course, you've also got the text, which I think is relatively clear.
All right. Thoughts?
No. For starters, I don't think originalism is the correct interpretive method to ever.
That's a different panel.
That is a different panel. But in particular, in this context, we're talking about people who own slaves. So I don't think that looking to their views, or even the views of if you want to use general public meaning at a time when lots of people had slaves, I don't think that's how we should be interpreting the validity of racial non-discrimination laws. So that's one piece of it. I also think that, so the 1964 Civil Rights Act was justified under the Commerce Clause. Part of the reason for that is who the committee chairs were. They literally did the Commerce Clause and not the Section 5 of the 14th Amendment, in part because that committee had a segregationist running it. And so, again, with the lobbying, how the sausage gets made, but and part of that was also the original civil rights law had been struck down by the Supreme Court. And now we have Morrison saying essentially that Section 5, 14th Amendment doesn't extend to private action. I would argue that's incorrect and should be revisited. I think there's a good argument that if we want to talk about the framers of the 13th, 14th, and 15th Amendment, and the meaning of those requires us to cease discrimination on the basis of race.
Questions from the audience?
Still first,
Go for it.
thank you guys, this has been so great. Is preventing discrimination in and of itself a compelling government interest that they could kind of win on, even if you get the strict scrutiny? Is that sufficient?
So I think to respond in part to the last comment, absolutely with respect to race, like Bob Jones, Loving, like I think that's clear with respect to race.
Thoughts on that?
I don't think there's a way to draw a meaningful distinction between discrimination on the basis of race and discrimination on the basis of LGBTQIA plus status without evaluating the legitimacy of the religious argument itself. I don't doubt the sincerity of the gentleman who owned the barbecue restaurant in South Carolina, his religious sincerity at that time. Lots of people were making those arguments at that time. And so if we accept the sincerity, and we can't have the courts evaluating the merits of religious arguments, then it's hard to see any principled distinction for other protected classes as well.
Sure. So to respond to that, I think the distinction comes in on the compelling interest side. So even granting that there's a substantial burden on a religious exercise, the piggy park guy, even if that was a substantial burden, even spotting him that, the question is whether there's a compelling government interest that still allows the state to apply. And I think that gets into the categories you were initially talking about. And the court in Scrimeti talked about, are certain categories actually immutable or not? I think folks agreed in Scrimeti, maybe not. So I think all of those sorts of things would play into the compelling interest analysis.
Okay. Other questions? Yes, sir.
So, having no familiarity with discrimination law, I seem to recall that Title VII has a provision for religious discrimination. How do you think religious conscience and anti-discrimination on the basis of religion interact if an employer has a religious view that doesn't align with an employee's religious view? Which religious view wins out?
Sure, it's such a super interesting area of law. It's called the co-religionist exception. So for example, if you're a charity, then you can only hire those that share your religious beliefs. And sometimes it makes a lot of sense. If you're a pregnancy care center, you probably don't want to hire someone that's advocating for abortion, those sorts of things.
This is somewhere I have notes on this. Yeah, I think that it's a really interesting issue, but I think it can go to what a reasonable accommodation is, right? If you have, if all of your employees share the same Sabbath and you need someone to work on that day, it might not be a reasonable accommodation for you to give everyone that day off. But so this is where religious diversity would actually be beneficial. Because you're gonna have some folks working on Sunday and some folks working on Saturday. I think I keep bringing this back to harm, but I think there's harm in refusing to hire somebody or refusing to give them an accommodation because you don't like their religious belief, or trying to impose your religious beliefs on your employees, for example, by refusing to cover certain things under your employee insurance plan, versus, simply tolerating that diversity of views, that a distinction can be drawn on that basis.
Yes, sir.
Somebody had mentioned that judges interpreting the validity of certain religious exemption claims runs into establishment clause problems. And I thought of Holy Trinity that case and that this is a Christian nation. So perhaps there's some room to talk about that, but I guess more specifically, my question would be, is there an underlying assumption in some of these cases that obviously racial discrimination is not a valid religious sort of doctrinal thing, then these maybe ministerial claims are? Is that happening in the background? Should it? Is there this factoring in?
So I think yes, although I don't know that I'd frame it quite that way. I think the ministerial exception cases, as Ken said, are unique in that it involves church governance. So it would be quite probably an establishment clause problem, but also free exercise violation for the government to say, you need to hire this minister that applied. He needs to preach on next Sunday, or she needs to preach next Sunday. So that's a clear religion clause violation. And I think it's also clear for different reasons, focusing on the compelling interest prong about racial discrimination.
I think it's worth pointing out that it took us a very long time to get to Bob Jones. That case was decided in 1980, right? And so, and even, if you look at like Brown versus Board of Education, if the Supreme Court had decided that case 20 years earlier, things would not have gone well. As it was, they had to send out the National Guard, right, to enforce that decision. And so there is an element that we as lawyers don't necessarily like to talk about of the court responding to shifts in our culture and in our society, right? And so LGBTQIA plus community rights have very clearly not come as far as racial justice has. I think I hope we are on a path towards greater acceptance of queer people and towards someday having our own Bob Jones case. But we are not there yet. And I think that this goes back to, again, like who gets to decide, right, who are in those categories. And I think there obviously has to be an element of our society and our legislatures making those decisions rather than the Supreme Court going it alone.
I'm going to use my privilege and ask a follow-up question to the question that was just asked. A little bit broader question. So you've talked about RFRA, RLUIPA, which applies strict scrutiny to these questions. And I think a lot of people would say, if that's what we're looking at as sort of we want that, there's some negatives in there. And one of the negatives is judges are having to decide whether people are sincere or not in their religious beliefs. Judges are having to make calls about, is this close enough? You're not actually performing the abortion. You're just telling someone to get, like you're sort of making these calls. And judges are having to decide how long beards can be in prison. Just, generally, we just would rather not do that. Any thoughts about sort of the practicality of sort of a system of litigated religious exemptions from either of you?
I mean, I don't disagree. I don't want you deciding how long my client's period could be. And I do think it is incredibly onerous and one of the benefits of Smith. I mean, I think that it is problematic for court, and I think there is evidence of courts unfortunately not taking, in some cases, the rights of people from minority religions, from small traditions that the judge may not be familiar with as seriously as beliefs with which the judge is very familiar and may personally hold, may not, but has and so that is a problem, and then it is a difficult problem to avoid when you are putting that onto the court.
Any thoughts?
Sure. So I think I just have to go back to the First Amendment writ large. And I think if you're going to talk about original meaning, there's at least as much, probably more, evidence for the free exercise being a fundamental right than there is for free speech. I mean, they're obviously both in there, but the history is really good, at least in my opinion, for free exercise rights. So while I appreciate the practicalities, I think that's what you have to do with fundamental rights, unless, I guess they're both tests in some respect. It's certainly true that Smith, unless there's these sorts of exceptions, which actually, the exceptions are such a mess anyway. I don't know that it would actually save you any time. So I don't know. But I think the fundamental right, I think you have to do.
All right.
Can I just say one thing also about the practicality, is that I think this comes up in the emergency care context, right? It's one thing and arguably that I would say a bad thing, but it's one thing to have to travel a significant distance to find somebody who will provide you abortion care when you have time to do that. It is quite another thing when you are experiencing a miscarriage and at great risk of dying and you're unable to get the care that you need. And so I do think there are important distinctions, particularly like in rural areas, where all of the hospitals might be, and providers that you have access to are religiously affiliated and won't provide certain types of care. Even if it's not an emergency, if you want to get certain types of care and you have to drive for hours, that you may not be financially able to do that. And so I do think, those are important considerations.
All right, we've gone over, but we started late. Let's do, do y'all want to just do a wrap up? And I mean, I forget who let's see, you started, so why don't you start the wrap up too? That way, Cam can get the last word.
Yeah, so if we're taking the text of the Constitution seriously, which I think we absolutely must, I understand and agree that there are problems with the way our country was at the beginning. Women couldn't vote, slavery obviously existed. But if we throw out the system, we throw out representative democracy, and as lots of people have said, I think it's better than any of the alternatives. So I think we're stuck with the whole thing. And I think the free exercise clause is a good part of that. I'll just leave you with one example that came out in the last administration that I think shows the dignitary harm that can occur on both sides of this. So it's called Section 1557. It was through HHS, and what Section 1557 said was that if you received what's called CHIP age, so it's basically Medicare for kids. And so if you are a pediatrician, if you are a surgeon who takes those sorts of federal funds, then you are required to provide cross-sex hormones, and you are required to provide top and bottom surgeries. There's like this provision says you might have a religious exemption, but we're not going to say. But here, I think you can clearly see that it might violate someone's religious beliefs to do those sorts of surgeries or provide those sorts of drugs to someone they think was created beautifully as they are. On the other hand, you might have parents and children who think differently. But I think the concept of dignity doesn't get us out of this problem because we have both equality and liberty rights, but we also have dignity interests on both sides.
I'm actually going to close with a quote from a case that says this far more eloquently than I can. This is a New Mexico Supreme Court case about and it relates to a wedding vendor. Okay. At some point in our lives, all of us must compromise, if only a little, to accommodate the contrasting values of others. A multicultural, pluralistic society, one of our nation's strengths, demands so no less. The plaintiffs are free to think, to say, to believe as they wish. They may pray to the God of their choice and follow those commandments in their personal lives wherever they lead. The Constitution protects them in that respect and much more. But there is a price, one that we all have to pay somewhere in our civic life. In the smaller, more focused world of the marketplace, of commerce, of public accommodation, we have to channel our conduct, not our beliefs, so as to leave space for other Americans who believe something different. That compromise is part of the glue that holds us together as a nation, the tolerance that lubricates the varied moving parts of us as a people. That sense of respect we owe others, whether or not we believe as they do, illuminates this country, setting it apart from the discord that afflicts much of the rest of the world. It is the price of citizenship.
All right. Well, thank you very much for having us. This has been so fun. So I guess we'll clap now, right? Okay.
And I have a final word. That was so wonderful. Give one more round of applause. Such a great debate.